Hello, everyone, and welcome to our webinar, Harassment, Social Media, Defamation, and Restraining Orders. My name is Miranda Ward, one of your client relation directors here with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to go ahead and get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. This video will be available on our YouTube channel after the webinar is processed. We're going to go ahead and post a link into the chat for a direct access to our YouTube channel right now. We will be taking questions via the Q&A function to be discussed at the end of the program. If we do not get to your question, please check the newsletter. Please remember some questions may be answered as the presentation progresses, and too specific of questions will not be addressed. If you have too specific of a question, you need to reach out to legal counsel. Now, on to the presentation. Please welcome Rob Ward and Jason Savlov.
Hello, everyone. I'm Rob Ward. It's good to see all of you, although I can't see all of you. I see that there are many participants on this webinar, and we appreciate your time. We're looking forward to presenting this little program for you today. Jason, do you want to say hello?
Hello. Yeah, echo the same sentiments of Rob, and really think this presentation should be helpful on harassment.
Yeah, just real quick, I'm the partner in charge of Orange County area for Davis-Stirling, and Jason is the partner in charge of litigation. And so a little bit of general counsel and a little bit of litigation are going to be discussed today with respect to our topic. And our topic today, hopefully the PowerPoint gets placed. There we go. So that's us. And our program today is about basically 4 areas. They're all sort of interrelated. What we're going to cover today, if we can go down to the next slide, and then the slide after that, since you know who we are already, this is what we're going to cover. We're going to talk, first of all, about harassment. I'm going to take that on and give you a little spiel about what harassment is, how it's defined, how it applies to community associations, because that's really where we make our bread here, is with community associations and advising those associations. And it's my understanding that there may be some board members online today and some managers who need a little bit more of a fine tune on what harassment really is and how we go about combating it. I'm going to discuss that for a while, and then Jason's going to come in and talk a little bit about some of the legal remedies that you can use to combat the harassment that maybe you are experiencing, or residents are experiencing, or board members. And that involves the filing of restraining orders, temporary restraining orders, civil harassment restraining orders, and how that differs from what we call injunctive relief. And I don't want this to get too legalese because we're not in law school today, but we're going to have to talk a little bit about that and how it works and how civil harassment restraining orders work. And the fact that there are actually, as of January 1st of this year, new protections for HOAs with respect to filing those restraining orders. So Jason's going to tell you all about that. And I'm going to come back and talk a little bit about defamation law. And that gets a little dry sometimes, but defamation is something that a lot of people have questions about. And they talk to me a lot about what defamation is and whether they have a cause of action and what those causes of actions look like. So I'm going to talk a little bit about that as well. And then, interrelated with defamation sometimes is the fact that we all use social media. Most of us do anyway. There are some that have managed to stay off it. Unfortunately, I'm on it, and I know that a lot of you are as well. And so we're going to talk a little bit about the use of social media and some examples of that social media and how you can properly use it, develop policies to protect yourself from things like defamation. And so that's what we're going to do today, and we'll hopefully have some time at the end to answer all of your questions. But I'm going to go right into the next slide now, and we're going to talk, if we can go to the next slide, please. We're going to talk about dealing with harassment. And there you see our little graphic on all the different types of harassment you might be experiencing. Harassment is something that, let's face it, everybody in some way, shape, or form is sort of dealing with at this time. especially with respect to the fact that we all deal with community associations. Some of us live in community associations. Many of us manage those same community associations. And when you've got so many people living together on top of one another, you tend to deal with issues involving what we call harassment. So we need to talk about where that comes from. The chances to experience harassing behavior are just increasing exponentially as a result of the fact that we're constantly improving our methods of communication. You know, it's more than just having a next door neighbor at this point. We have online issues now. We have different ways of getting to each other and more efficient ways of disseminating information. And with that, it increases the chances for people to get harassed or feel bullied or feel in some way uncomfortable. And so we got to talk about what constitutes harassment. Where does this harassment come from? I'm sure that many of you may feel harassed sometimes by your spouse if they tell you, hey, go do the dishes, go clean up your room, etc. I know I feel that way sometimes with my spouse. But is it really harassment? Not necessarily. You may feel harassed by your boss, that he's or she is imposing upon you some deadlines that you think are unfair, or being a little bit bullying about what they're doing. Is that considered harassment? Let's talk about the realm of HOAs, though, because that's really where we spend all our lives. And harassment can really be from many different sources and in many different facets. It could be a homeowner versus a board member. You could have that same homeowner versus the community manager. You could have the manager versus the owner experiencing harassment issues, board versus owner, board versus manager, owner versus vendor. Vendors play into this as well. So there are many different ways of experiencing what we call harassment. So let's talk about what that means and go to the next slide, please. What is harassment? Well, we define it in federal terms. We define it in terms of harassment in California law. Harassment is defined federally as a course of conduct that's directed at a specific person that causes what we call substantial emotional distress in such person, and that serves no legitimate purpose. So there's the code section on your screen for that. And harassment can be experienced, like we said, in different ways. It could be the harassment of residents in your community. It could be the harassment of vendors, like we talked about before, and I'm seeing that more and more. It could be the harassment of board members themselves, of directors who are simply volunteers trying to do their jobs. Or it could be addressed in terms of the harassment of employees, which does take place in the realm of community associations. In California, harassment can be shown in different ways. They can fall along the lines of obvious physical attacks, which I have had to experience, unfortunately, not myself, but my communities that I represent, where physical attacks have taken place. And so that can be considered harassment, not just a felony. It could be repeatedly unwelcome phone calls or emails. The Penal Code of California is specific and says that any of the following acts that I am going to talk to you about now can be considered harassment. It could be assault. And some people misinterpret what assault actually is. It's any intentional attempt to cause any physical harm to another person. And that's an attempt. That doesn't mean that it actually happened. But most people think that it literally means that there's some unlawful violence that has been committed or that someone has been attacked. But it could be like throwing a household item at somebody. Even if no harm is caused from that, it's an assault, and it's unlawful because there was a clear intent to do harm. And along with that, of course, is battery. And battery usually accompanies assault. And battery is when you actually throw that object at the person and it hits them. So the battery is classified as something that does cause that physical harm, that someone has been somewhat injured in the process. This is common in cases of domestic violence, but it's also considered harassment. And so that is a part of this. When someone is acting with the credible threat of violence, when someone's threatening another one, and you're threatening to kill or physically injure another person, and they experience some sort of reasonable fear as a result of that behavior for their safety, for the safety of their immediate family, this can be considered harassment. All right, stalking. Stalking is something we hear about. Stalking in the California Penal Code is classified as any repeated series of actions that may take place for a victim in fear of their own safety or their immediate family. Someone physically following someone taking constant videos of that person and walking around and following them, and sending emails, making repeated phone calls, or an attempt to scare someone going online, and what we call internet trolling, which we'll talk about in a minute. It's any attempt to scare or intimidate or annoy someone. That's harassment. That is actionable. It can be very similar to stalking, harassing behavior, repeated actions that are intended to scare someone or annoy, that don't have any legitimate purpose. And so we'll talk a little bit about that, but it may include someone making unwanted phone calls, sending text messages repeatedly over and over after being asked to stop, consistently saying things that place someone in some reasonable apprehension of fear. This is all what you could consider to be harassment. So let's go to the next slide. And we're going to talk about how harassments or how harassment is experienced with residents in our communities, and how do we as managers and board members address this type of nuisance behavior. And notice I said nuisance behavior because the next slide is going to discuss a little bit about how that works. The nuisance provisions in your CCNRs, those are designed to protect from things like harassment. Members are prohibited from causing or permitting any act or condition which unreasonably disturbs or annoys or is unreasonably injurious to the health, or indecent or unreasonably detrimental to the persons or property. These are provisions that you find in your governing documents that are designed to help protect you. A typical nuisance provision could be something like there is no illegal or noxious or offensive trade or activities that shall be conducted upon any lot or within the common area, nor shall anything be done thereon which may be or become an annoyance or nuisance to neighboring owners. So it's sort of a catch-all provision that serves to protect from this type of what we consider to be illegal but unreasonably bad behavior. And it certainly encompasses this harassing behavior. It provides the association with the wherewithal to go ahead and employ its enforcement options and address the harassment as part of its fine structure. So this is what board members can do when they first experience this type of behavior. It's the first place you find the authority to address it is in your CCNRs, your governing documents. We can certainly rely on the civil code as we go forward, but the first place you're going to look is your CCNRs for that provision. And that's not to say if there's some weird, egregious behavior that's going on that board members or residents are experiencing, that they shouldn't call the police, because that's exactly what you should do. If something is happening that appears to be illegal, that is so bad that someone is in fear for their safety or their life, you call the police and you get them involved immediately. You don't rely on the enforcement options that you have, because those take some time. And sometimes it's more problematic and more important that you get the police involved, get a police report filled out, and get law enforcement if it's appropriate. The result of that is that a police report could be generated that would be useful evidence later if you have to take any further steps down the road in the legal process that Jason's going to talk to you a little bit more about later to deal with this harassment. And we're going to get into that pretty soon. So let's go to the next slide and talk a little bit about your board duties. If your boards have a duty to investigate and act on harassing behavior complaints. And they do so in particular when it has to do with a protected class. HUD, which is the Housing and Urban Development Department, offers certain specific categories in California that are considered protected classes. And sometimes people don't realize that there are several different protected classes that need to be protected, to be honest with you. Race, color, religion, sex, familial status, natural origin, disability. All of these are categories that have been discovered to be protected classes by the federal government. And so when does this come into play? And fair housing is what I'm talking about. When does fair housing become an issue that will trigger harassing behavior based on what we call possible discrimination? Discrimination is something that every board should be familiar with and keep their eyes open for. If we go to the next slide, I will show you what I'm talking about. In California, the Fair Employment and Housing Act, FEHA, has defined harassment as any unwelcome verbal, physical, or visual conduct. This also includes sexual harassment. We're not going to talk too much about that. It's more in the employment realm, but it's defined as unwelcome sexual advances or other conduct of a sexual nature. And there are even more categories under FEHA of possible discrimination. It's not just race or color or religion. It does get very tricky and get very complicated very quickly when these issues arise. And so what you see on your screen are different categories of FEHA protected classes. More than just race, color, and religion, you've got things like citizenship, age, gender, sexual orientation, gender identity. It could even get into things like the source of your income or your familial status. These are all potential sources of discrimination that require boards to investigate when complaints are made. And this seems like it's getting outside the realm of harassment. It's not true, because those who are protected do feel harassed quite often. And so fair housing will come into play at some point when these complaints are made. If we can go to the next slide. The Fair Employment and Housing Act will define harassment as any unwelcome verbal, physical, or visual conduct. So this does include sexual harassment, as I said before. But there are 5 main types, and that's kind of what I wanted to bring to your attention. There is civil harassment, and this is when a person is harassed by someone they don't really have any close family or romantic history with. There is domestic violence. This involves people who are being harassed or harmed by someone they clearly know very closely, and it could be an immediate family member, it could be a parent, a child, a sibling, obviously a spouse or former spouse, or it could be someone you're dating. They may involve physical harm from one person to another, unlawful violence. It could be the credible threat of violence. It could be stalking. All those categories that we talked about a few slides before can be part of this harassment that involves a fair housing issue. Another category could be elder or dependent harassment or abuse. It's sort of the same thing, but it has to do with when the conduct is against a person over the age of 65. And it does carry with it significantly more sanctions. There is also workplace harassment. We're not going to get too far into workplace harassment, although the interaction between managers and boards sometimes do involve issues involving workplace harassment. It's when an employee is treated worse because of a protected characteristic, to the point that it creates an abusive working environment. And so that could be another possibility for harassment. Some examples are when, say, an employer fires or demotes you or cuts your pay or reschedules your shift. And it's all because of one of those protected categories that we talked about before. So that could be harassment. There is also sexual harassment, and like I said, we're not going to get too far into that, but keep in mind that sexual harassment is sort of its own entity and will involve issues of fair housing as well. Go to the next slide, please. And we're going to talk about the duty to investigate. The boards of directors, when alleged harassment occurs and it's reported, what is a board supposed to do? It does have a duty to investigate this particular behavior. Boards have to investigate reports of these harassing issues, or what they could be facing is a complaint being filed with the with the Department of Housing and Urban Development, which is then referred over to the Department of Fair Employment and Housing, DFHA. So when that process begins, it becomes serious, and what you need to do is consider right up front, before any of those complaints are filed, doing your due diligence and investigating the matter as thoroughly as you can. You need to call the accuser to a hearing. You need to ask for any evidence that you may find. If there's any recordings of the harassment being done, if there's any written materials, anything that would tend to support the claim, review it and find out if there's any teeth to it. And if there is something to be done about it, great. But you do have that, as a board, you do have that obligation to investigate that behavior when it becomes reported. Even if it seems minuscule, it's important to take it seriously. Let's go to the next slide and talk a little bit about guidelines. Boards can evaluate unwelcome conduct, as I said before, by gathering that evidence. They need to consider the context in which these incidents are occurring, the severity of the incidents, the scope, the frequency. Is it going on over and over again? Is it a repeated occurrence? Is it something that only happened one time? How long did it happen? Were the police involved? Where did the conduct take place? Is that a venue where this conduct is taking place more often than not with other people? The relationships of the people involved. There are a lot of different factors to consider. And the harassed person, keep in mind, does not necessarily have to prove that he or she suffered physical or psychological harm to have a claim for this harassment under fair housing. So these are things to consider. I know that interacting with people in communities is tough sometimes, and you know that people experience things differently. But when you do get these complaints that are based on these protected classes, they must be taken seriously. And I encourage all of you, if you experience this, to consult with legal counsel and get an opinion on how far this could go. And with that in mind, let's go to the next slide and talk a little bit about what you can do about harassment. And that means you adopt anti-harassment policies. There are all different types of policies that you can adopt that make your lives easier as a board and as managers that your boards can implement. But adopting an anti-harassment policy is something that will be really useful to your communities, because what you can do that way is define what you mean by harassment, what behavior is included, what proper behavior could be, what improper behavior should be, and have that sort of defined in a clear policy. Set limitations on what your HOAs can do and let people know what they can do, how they can enforce anti-harassment or harassing behavior. Define what is prohibited versus what is permissible. You know, what could be prohibited could be things like sending unsolicited mailings or emails or texts or instant messages or posting on social media to a director regarding HOA's business, unsolicited conversations, stalking, harassing a director. Again, I have a case right now where there's a resident who walks around the community and constantly films everybody with their cell phone camera. And it's because he believes that he's being discriminated against, and that's where the fair housing comes into play. And so he's gathering evidence. He thinks he's gathering evidence, but what he's doing is actually harassing others with that behavior. And so this can all be implemented into a clear anti-harassment policy. And we talk about what's prohibited and what's not allowed. Excessive communications, sending, leaving, or making multiple emails, voice messages, text messages, phone calls to board members or other residents. That's stuff that can be clearly defined in a policy. And you can say what's permissible. You can say that communicating directly with a board or manager only during a certain allotted period of time or at an open forum in a meeting, that's permissible. Only if recognized by the chairperson of the meeting. You know, keep it official, keep it organized. At hearings, members can communicate when recognized by the chair at any disciplinary hearing, or at an IDR or something like that. At other HOA functions, at any other HOA functions where, to the extent contact with the director is authorized by law or by the HOA's governing documents, then that's permissible. That's okay. Or if you've got written permission to engage in the direct communication. Those are all ways to sort of control that behavior and let people know that there are parameters and consequences to their actions. Okay, let's go to the next slide. Talk a little bit about vendors. What I'm seeing a lot of lately is when vendors are in the process of engaging in their scope of work, you know, landscapers, roofers, whatever it's going to be. And they feel harassed sometimes by the individual unit owners who are either directing them to do something outside of their scope, or yelling at them, or anything else to be considered that harassing behavior. Boards should take prompt steps to investigate the vendor's claims. If the vendor is reporting that they're feeling harassed by individuals out there in the community, then they need to investigate that and take those steps that we just talked about. We've seen a lot of infringements. I see a lot of it these days with vendors. It could lead to bad things like losing your insurance, or lawsuits from the contractor or the vendor himself. And possibly even blacklisting your community from other vendors. We don't want to see that happen. The boards do have a duty of loyalty to refrain from self-dealing, so board members certainly do not want to interfere with what vendors are doing and harass them as well. There are ethical problems involved. And once again, having a clear anti-harassment or ethics policy in place is going to help with that. And if we go to the next slide, we're going to talk a little bit about board members and the fact that boards are volunteers who tend to take a lot of abuse. Everybody kind of knows it. If you're a board member out there listening to this today, you've probably experienced something like this, where you've been harassed, or you've taken the brunt of an association decision that was made. Perhaps a special assessment had to be imposed for reasons of repairing deferred maintenance items or otherwise. And people just didn't take kindly to it, and they started firing emails at you, or making phone calls, or posting about you on social media, which we'll talk about. Well, boards have a duty to investigate and act on these as well, when these complaints are made. But what if the board members themselves are victims of the behavior? You know, on top of your enforcement through the CC&Rs, you know, members do have legal options to assist with ongoing episodes of harassment. And so if you're harassed and threatened, you could possibly need to file a restraining order. It'll be issued if the offender has threatened to abuse or abused or stalked or seriously harassed the board member, and the member is actually scared, seriously annoyed, or feels harassed. And we're going to find that the legislature has recently addressed this issue and has made it a little bit easier for HOAs to address this through the legal channels. Go to the next slide. I want to talk just real quick about internet trolls. I'm sorry, the next slide after that. I want to talk a little bit about internet trolls. And what do we mean by an internet troll? It's someone, as you know, who after you post something, follows you and disparages you, and perhaps uses profane language, who calls you names. This is a course of conduct. It's a pattern of conduct that's composed of a series of acts that happen over a period of time, however short, that evidences a continuity of their purpose, that they're following you, they're stalking you, they're making phone calls, they're posting, they're sending harassing correspondence, including public or private emails, inter-office mail, faxes, you name it. But social media is really the #1 source of all of this trolling. And so if you're experiencing that, you do have options. We're going to talk about those. Let's go to the next slide real quick. Before I get to Jason, just mentioning a case that came down, and it involves that the HOA paid legal fees. It's called the Benlock versus Johnson case. The HOA paid legal fees to get a restraining order to protect a director from a homeowner. The harasser, who was the defendant or respondent in that case, argued that the HOA did not have a right to pay the fees. The judge disagreed and issued the restraining order and awarded attorney's fees. So if you're wondering whether you can get attorney's fees in restraining orders, you certainly can. Jason will talk a little bit about that as we go forward. But I'm going to go ahead and turn this over to him on the next slide as we talk a little bit about employees and what employers are required not to do.
Thanks, Rob. Yeah, well, just to move it along, let's move to the next slide, and actually to the joint employer slide. So next slide. So to touch base on joint employer liability, the association, when it hires independent contractors, might be treated as a joint employer. So that means even if the association hires a 1099 vendor, and the association exerts certain control over the independent contractor, the association may be on the hook for the independent contractor's harassing behavior against an association employee. Moreover, I just wanted to emphasize that in addition to being potentially a joint employer, that the association is also potentially exposed to negligent hiring, regardless of whether you're a joint employer, the association's a joint employer, and should work with their legal counsel and managers to ensure every vendor is vetted within industry standards to not be exposed to negligent hiring. For joint employer purposes, there's a federal standard, which is a little stricter than the California standard. And those factors in determining a joint employer are whether the association exerts hiring and firing of the independent contractor. Does the association supervise and control the independent contractor? Does the association determine the amount of payment and how they're paid to the independent contractor? And lastly, do they maintain employment records of the independent contractor? So you kind of look at the mix and see how much control the association has over that independent contractor, and there may be some joint employer liability if there's more control than not. An example you might see in the industry is management companies sometimes provides a general manager to a high-rise building. And then the association interviews candidates from the management company for their general manager and chooses who the general manager is. The association makes their schedule, what hours they come in. Some hours they come in, 40 hours a week, and then they, sometimes they only need them 30 hours a week. Maintaining discipline records. So maybe if there's notation in a file that, hey, the general manager didn't come to work on time, that might be considered an employment record. Has a history of, if the association also has a history of terminating prior general managers at their location that the management company provided. With all those factors, you might consider the association as a joint employer with the management company. But you need to, with these type of scenarios, you need to go over that with your legal counsel to see if you're exposed to that joint employer liability. And again, California has a broader definition, and should consult their legal counsel if there's a concern over whether violating a California joint employer liability. I'm now going to move to the next slide and talk about restraining orders. And I'm going to get into what's the difference between a restraining order and an injunction. A restraining order prohibits certain conduct by the wrongdoer, such as stalking, harassment, threatening, some of the conduct, and that can be issued to protect a board member, employee, or vendor. And the restraining orders can also protect the household members of the protected board member, employee, or vendor, if they so desire. And vendors that are protected are typically managers. That's what we most likely see in the instances of issued restraining orders. But I've also had landscapers protected, security guards protected, contractors, installing, let's say they're installing cement and someone's yelling at them uh, for installing it, and I've seen that. So sometimes the association needs to get involved to protect their vendors so they can do their business with their vendors. Also, typically a restraining order has a stay away order, and it needs to be tailored depending upon the community. So, for example, if you have a condominium or a high rise, you might have a 5 to 10 yard stay away order that the protected person is, that the person that's the wrongdoer has to stay away from the protected person 5 to 10 yards. Versus if you're in a planned development, it could be 100 yards, and that would not be unrealistic because you might live on a different street, and so 100 yards might be the stay away order. Also, when you get a restraining order, the wrongdoer has to give up their guns and gun parts and body armor. And the body armor, it's defined by the penal code, but some of those kind of protective armor against weapons would be also have to be given up while the restraining order is active. Next slide. So we have this new workplace harassment legislation that went into effect as of the 1st of this year. And the legislation expanded this Workplace Violence Protection Act to include harassment. So previously, let's say we were in 2024, the associations were only limited when wanting to file one petition against a wrongdoer committing credible threats of violence against a board member, employees, or vendors. And they weren't allowed to, the association wasn't allowed to file a harassment petition in this all-encompassing restraining order petition. Instead, previously, if wanted to protect a harassment, let's say a manager and maybe a couple assistant managers, we'd have to file multiple petitions under the Civil Harassment Act in order to protect them. But now it's been combined into the Workplace Violence Act so that you can protect several people under one petition. So it makes it a little bit more efficient. And Rob talked about what harassment is. And just a reminder, forms of harassment can be stalking the association within the association or place of business, such as in the management office. That happens, where they go to the management office and start yelling and screaming and so forth, and demanding things be done right away and so forth. And also it can be, telephone calls, emails, and mailings. And we're definitely seeing a lot of the email harassment and also telephone calls, leaving messages, and then leaving messages for their supervisor and taking it all the way to the manager's president and telling how horrible a job the manager is doing. And I mean, this can be considered harassment if they continuously make these calls. One example I had was a stalking example where a restraining order was issued in a high rise where a resident would follow the manager into his office, and it wasn't a locked office. They got a lock later, but he'd go in there several times in a week and just start shouting demands to the general manager, which obviously is not the behavior to get things done. And a restraining order was issued. new this year is that the employer, so the association, has to provide an opportunity to the protected individual to opt out of the restraining order. So before, you could try, with your diligence, try to do a blanket protection. Sometimes I saw it with, security guards. Maybe there's 5 or 6 security guards at the gate, or that are being harassed, and so they'd throw in all the security guards without even asking them. Well, now you need to ask each individual if you want to be protected, and give them an opportunity to opt out, which makes sense, because some people, these restraining orders are transmitted to a law enforcement database. So all law enforcement has all the names of the protected individuals, and some people, they just don't want they don't want to be in a database, or they're macho, and they think hey, this guy's not threatening me. It might be threatening the other guy, but not me. I don't want to be in there. So this now it'll be just as a matter of practice, asking each individual, do you want to be included in the restraining order? And it makes good sense. Next slide. So there's differences between a restraining order and an injunction. Both of them prohibit conduct, but there are different types of tools that your legal counsel, when you work with them on harassment, to use. An injunction is typically a breach of the CC&Rs, or nuisance conduct, and the restraining order is just a quick harassment petition. Some of the differences are time. Restraining order for harassment is typically quicker to achieve. You just file a form petition with the evidence, and you may receive a restraining order the same day or the next day, depending upon what time you file it. And you get a hearing about 20 days out. With an injunction, you need to prepare a complaint, a lawsuit, and you need to, which, depending upon the circumstances, might take time and to gather the evidence and prepare. And then also you have to prepare an application for a preliminary injunction or temporary restraining order, which also takes time. But in a pinch, we can get a potential temporary restraining order and go to a preliminary injunction in a quick amount of time. But in general, injunctions take a little longer than the harassment petitions. Cost is a factor. Again, if the restraining orders are quicker, they cost less than an injunction. With an injunction, you have to file the lawsuit, and you can file your filing fees and all that, and it heads towards trial. So even though you might get a preliminary injunction and it stops the conduct, if they don't stop, then you've got to do other maneuvers, and there might be discovery and other expensive motions and so forth. So an injunction is much more expensive, depending upon how contested and so forth, than a restraining order. What's the difference in service, or is that you need to serve this within 5 days of the hearing? If you don't, for a restraining order, either you get a continuance to serve again, or they might dismiss it, and then you might have to refile. With an injunction, you can do what we call an ex parte notice within 1 day to get a TRO. So there's differences on service. Thresholds of proving your evidence is also much different. So the restraining order has to be clear and convincing evidence, which is a much higher standard than an injunction, but it's lower than a criminal case, which is beyond a reasonable doubt. Injunctions, all you need to do is prove that you're more likely than not to prevail in your litigation, which is a lower standard. And we talked about who you can protect in the restraining orders. It's the board members, employees, vendors. With an injunction, it's more broad, and depending upon the circumstances, you might be able to protect residents in the association. So sometimes, depending upon your circumstances, we talk about it like a dual approach. Get a restraining order now to protect the board, employees, or vendors, and let's go for an injunction to protect the residents. So that's a possibility. Also, enforcement's different. Restraining orders, you can enforce via sheriff and police. You just give them a call and they enforce that day. With the injunction, you need to talk to your attorney, get them the evidence, and then file a motion for contempt. So they're much different, and it takes much longer to enforce an injunction than it does to enforce a restraining order. The length, their difference, usually it's 3 years for the workplace violence petition or the new harassment petition. But if you file under the old way, which is the civil harassment, and that still exists, civil harassment petition, you can get up to 5 years. And the injunction, they can be permanent injunctions, so it lasts longer. Attorney's fees, as Rob said, there's maybe ways to get attorney's fees, but really under the statute for workplace violence harassment, no, there's no attorney's fees recoverable. You can try, but under the statute, if it was ever appealed, it clearly says cannot recover your attorney's fees under the workplace violence petition. But with the injunction, it's typically coupled with the CC&Rs, breach of CC&Rs. So you get the Davis-Stirling Act and also your CC&Rs that typically have attorney's fee provisions. So yes, you could obtain attorney's fees if you're the prevailing party. Next slide. Reduction of liability. Let's actually move on. Let's move on to Rob with the defamation.
Yeah, sort of the same thing with reducing liability. Develop your policies, immediately investigate your complaints, etc. And then when it comes to defamation, we're kind of short on time. I'm going to kind of blow through this a little bit because some of it can be really a legalese type of, but I want you guys to have a basic understanding of what we mean by defamation. And so emotions really do run hot in HOAs. Boards and owners are occasionally tempted to say nasty things about each other. But look, words and writings can spark lawsuits. And both boards and owners should know that what they can and can't say in order to avoid serious liability. So what is defamation? Well, it can be either written or spoken. And so there are different aspects to each. And written defamation is what we call libel. Libel is defined as the false publication, and that includes writings or printings or pictures or hanging somebody in effigy, which has happened before, or any other fixed expression that someone's eye can catch that is not protected by the law. And it either exposes a person to hatred or contempt or some sort of ridicule or censure or reproach, or it causes this person to be shunned or avoided. And it has a tendency to cause some sort of injury to their reputation. That's libel. That's in writing. Slander, slander is spoken. It's a false and unprivileged spoken publication against a person. And it could be something that charges a person with a crime that he hasn't committed, or he's been indicted or convicted or punished for a crime that isn't true. or it imputes the existence of some sort of weird, infectious, contagious, or loathsome disease, or tends to injure someone with respect to his employment, his office, his profession, his trade. By imputing, like, generally he's disqualified in those respects, or isn't doing what he's supposed to be doing, or anything concerning the person's office or profession or trade that has a natural tendency to lessen the person's worth, or it imputes impotence or the want of chastity. That could be part of slander, and it has to cause actual damage. So it's basically a statement that was false, that was purported to be true, that was harmful to the person's reputation, that was actually published or spoken to somebody outside of just those two people. It was a third party that heard this or more. And that statement was published with some sort of fault. That means that it was published through either negligence or with what we call malice. So we go to the next slide. Defamatory statements are statements of fact that exposes others to hatred, ridicule, or contempt, that tends to reflect unfavorably on their morality or their integrity. It discredits them financially and their standing in the community. These statements don't have to offend everyone, by the way. It's just a substantial number of people that might be offended that defamation can be attributable to. Any statement of opinion, by the way, is not actionable as defamation unless you're implying some sort of false underlying fact is true. Next slide, please. Keep in mind that the statement has to be published. Okay. One of the elements of the tort of defamation, and by tort I mean it's something that is injurious to someone, is that it has to be published. It has to be communicated to a third person who understands that defamatory meaning as applied to the plaintiff, that they understand it, and it's either been through writing or spoken in some way, and it suggests that a common meaning of that term that someone actually understands. The intentional or negligent communication to someone has to be other than the defamed person. That person has to fail to remove the defamatory matter known to be exhibited. It could be something that's posted at a clubhouse or by the pool. It could be something that was posted online in a newsletter. I have a case right now where someone is sending out or posting flyers in a large community and going door to door and posting flyers with defamatory material contained in that. That's publishing, of course. It's a flyer. He's starting to send it via email now, and publishing and republishing that can subject you to a claim for defamation. Next slide, please. There's a little bit here about libel and slander per se. It just means that it's actionable in and of itself. This is getting a little bit legalese, so I'm going to keep going with this and get to something else I want to talk about. So if we go to the next slide, there is a requirement of fault. There is liability for defamation if you know that the statement you're publishing or speaking is false. That's intentional conduct. That's the malice we're talking about. Or if you've acted in disregard, reckless disregard for the truth in publishing that information. Or if you negligently fail to ascertain the truth of your statement. If you're saying something and you're not sure whether it's true or not, maybe you shouldn't be saying it. And so there are different standards for when you're either a private citizen or a public figure. If you're a private individual, you're only required to prove that the person that was speaking these defamatory statements was negligent in determining whether that issue was true or not. So if you're saying something, you should be sure that what you're saying is true. If you're a public figure, you have to prove affirmatively that the statement was false and made with what we call actual malice. I don't think anybody here is a public figure that we have to worry about. So let's move on and talk about potential defamation in HOAs. And in an HOA, an association can sue homeowners for defamation or defaming directors if it can be shown that the defamation is related to how the director performed his or her duties and responsibilities as a board member. So it's to have a natural tendency to affect the corporation, the HOA, disadvantageously in its business. There's a case called Palm Springs Tennis Club versus Wrangell that says that. If the allegedly defamatory statements can't be reasonably interpreted as having been made against the association, then the association does not have a cause of action for defamation. And the action is actually personal to the director. So the director may be the one that has been defamed and has that cause of action, but that doesn't mean necessarily that the association can bring that lawsuit. We talk a little bit about what malice is. It's defined as conduct that is intended by the defendant to cause injury to the plaintiff, or it's despicable conduct that's carried on by that defendant, and he has just disregard for the rights or safety of the person he's speaking that to. That's right in the Civil Code. Civil Code Section 3294 says that, and there's case law to support it. Malice usually includes, not only deliberate falsehoods that are being spoken, but also false statements without reasonable grounds to believe them to be true. And there's case law that supports that as well. So to establish malice, usually the plaintiff is required to show that the defendant made the allegedly defamatory statements with knowledge or reckless disregard of the falsity of those statements. So that's what you've got to prove if you're going to bring a lawsuit for defamation. You have to prove that the person making those statements knew they were false. And if they should have known they were false and they didn't do their due diligence, then they should have done that. So let's move on. We're getting kind of late here. There's talk about privileges. We don't need to talk about that. Privileges, keep going. Publication, there's a lot to this. I want to talk a little bit about the standard defenses when we get down past those privilege slides. And there's one more, standard defenses. So keep in mind that a defense to defamation is always going to be the truth. It's the essential condition of recovery. For a statement to be defamatory, it has to be false. Truth is an absolute defense to defamation. There's case law that supports that. Because that statement must contain a provable falsehood, courts will distinguish between statements of fact and statements of opinion. So keep in mind that if you're making an honest statement of opinion that's not based in fact for purposes of defamation liability, you may be protected for that. These privileges will turn up in executive session where you have attorney-client privilege. But even here, other individuals could hear the statements being made. So there may be an issue of defamation there. Again, statements of opinion are not going to be actionable. And there may be a lack of damages. We talked before when I first started speaking to you about the fact that one of the damages for a defamation case could be a retraction. And that's possible. But slander per se and libel, they can still lead to cases even if there are no damages. It's the best defense because individuals are not likely to bring a claim if they can't recover damages. So with that in mind, let's talk a little bit about social media because we're short on time, and I know Jason has a few things to say about social media.
Okay, we can talk about social media. Miranda, did you have anything to say or before I go in?
Nope, just that everyone is really intrigued to hear about social media. So please take your time. We are running a little long on this one, so we'll just hold questions for the next newsletter, or maybe we'll do another a webinar on this. But again, please take your time on explaining social media.
Okay. Well, we're all familiar, I think, with what social media is. Here's some of the list of the different types of social media. I think I don't even know if Foursquare still exists, but the interesting thing when I was looking into this, social media actually originated in some form back in the 1960s and 70s. Among us our computer, nerds back then, which included myself, that there was actual communication and so forth, the social communication on the computers, but it really didn't expand until the general population to what we know social media is until the mid 1990s, late 1990s. Uh, and of course, there's positive to social media in a sense that you get to socialize with others uh, and exchange ideas with people and around the globe even. So which is some of the positives or things you wouldn't have been able to do uh, uh, without social media but some of the negatives is obviously the cyberbullying and harassment. And so how does cyberbullying and harassment affect associations? Let's go to the next slide. So associations may be liable for harassment by its employees in social media when they represent the association. And sometimes this is difficult to differentiate. Um, you've got board members and potentially employees that often live in the association. So are they acting on behalf of the association or as a resident of the association? So sometimes we always think of two hats, especially with the board members. And we have to sometimes split hairs on whether or not, they're, going on to social media and acting on behalf of the association something officially, as in their capacity as a board member or as an employee, or are they doing this as a resident? And sometimes it gets a little muddy. Um, and that's why you need to kind of watch what you say online if you are in these positions of as an employee or a board member. Uh, it's also problematic that uh, that employees may say something on social media that's from their home. I mean, that's a lot of times when they get on social media, or even on their phone on vacation, might say something that implicates the association or another employee. Uh, it's hard to prevent also because usually it's on their personal devices. I mean, there are computers, potentially at their off place of employment, but it's also on personal devices. Uh, so let's look at minimizing exposure to the association. Next slide. So there may be ways to enforce, harassment and cyberbullying through the association's nuisance restrictions that are targeting employees of the association, which is one way. However, you need to be aware of within the Davis-Stirling Act, Civil Code 4515, which offers protections for speech. And there are a number of protections for speech, which allows residents to be critical of the association or its governance in the matters of development living, association elections, legislation, election to public office, and also in referendums or recall process. And there is also a broad what we call catch-all provision of any other issue of concern to members and residents. So it may be difficult to pierce the protected speech because a lot of issues that may be considered harassment are protected speech. But the same civil code also says that you're not required to provide, the associations are not required to provide a social media platform or an online resource or allow its members to post content to the association's website. So there's no requirement that an association needs to have a Facebook page or a Twitter page. And also There's no requirement to, if you decide to have a nice website for the association showing pictures and amenities and all that, there's no requirement to have your members have to be able to post to that website, and which may cut down on cyberbullying and issues with social media. Let's go to the next slide. So the risks and liabilities to the association. Someone posts someone's being a cyberbully. Defamation. So if you're allowing the defamation, you might be imputed as the association for the defamation. Also, Rob, talked about a defamation. Invasion of privacy is another issue. And fair housing, as Rob talked about. Could it be the association could be exposed to fair housing complaints if they let their social media get out of control, and also interference with contractual relations. Maybe some posts interferes. It could be both defamatory and interfere with the contract with a vendor, for example. So they lose business. So they have both potentially. If they say something untrue online, and then they interfere, also lose business with the association, that can have some liability. What you need to do is really work with your legal counsel on the governing documents, because there may be provisions in the governing documents that can be added. Adopting a social media policy, which provides clarity to the association's members and employees and board members, which could ultimately mitigate your risk and hopefully promote intended good use of social media, as we talked about, instead of the negatives. Next slide. So the best practices here are, you need to keep control. If you're going to have social media as an association, keep control of it, and work with your legal counsel on disclaimers, and consider governing document provisions, and adopt a social media policy, which mitigates your risk and promotes good use of it. And then there can be nefarious actors who also post fake pages and so forth. So there are various scenarios. Even if the association doesn't even have a social media platform and doesn't have a website, we've seen it where someone within the a resident has their own platform and has their own page. And what we recommend is work with legal counsel to mitigate risk on potentially the association being dragged into harassment or other type of liability. And that concludes our presentation.
Thank you again to all of our attendees and our speakers, Rob Ward and Jason Savlov. As always, please do not hesitate to reach out to us with any of your questions. We'll see you next time. And as a reminder, we will be following up on this either with a secondary webinar with your questions, or please look to the newsletter. I hope you guys all have a good rest of your day.